The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. Welcome back to Mediator in the Middle, a podcast about mediation by mediators for lawyers and their clients. I'm Abe Melamed, your host, and today we are really lucky to have an amazing guest, Sylvia Mayer. I really appreciate you being here, and we're really excited. Sylvia, for all the listeners and people watching, is an arbitrator and mediator and lawyer. I don't know if it's in that distinct order or not. But does kind of a little bit of everything in the alternative dispute resolution space, based out of Texas. You've got more than 30 years of experience, or is it nearly? Which one is it?
It is now a little over 30 years. I decided once I got to 30, I was going to stop counting.
Yeah, so you must have started when you were like 12, which is amazing. And you practiced in federal court, state court, bankruptcy, appellate courts, throughout your career. I think I saw you were at Weil Gotshal for a really long time. Is that right?
I was a partner in the Houston office.
And then on your own, doing a little bit of everything, but in particular, the ADR, and that's obviously what we're here about today. I know that you're on the roster for commercial arbitrators and consumer for the AAA. I know that you're a National Academy of Distinguished Neutrals Distinguished Fellow, American Health Law Association neutral roster, CPR panel of Distinguished Neutrals. So clearly not someone who just, dabbles in this space, but has a lot of experience. And I think that our listeners and viewers are going to be really, really fortunate to hear from you about our topic today, which is listening sessions. And, every mediator calls it something different. And I'm curious a little bit about how you came to that term. Is that something you adopted from other people or came up with on your own? But that's the core topic: listening sessions, catharsis sessions, whatever it may be, where the mediator allows the parties on both sides to kind of tell their story and feel heard. So starting from that point, or maybe even a step before that, did I miss anything in your bio that you think is important for people to know? Let's start there.
No, you pretty much nailed it. I'm an arbitrator, mediator, and attorney in Houston, and I serve as a neutral in cases all around the country, which is basically what you said. So Thanks for having me. I just want to digress for 1 second.
Please.
The fangirl. Because I love your podcast.
I appreciate it.
For all the listeners out there, if you haven't listened to all the prior episodes, you should, because I have found these podcasts to be really a deep dive into meaningful issues in mediation. So thank you for sharing all the wisdom you've shared through your program. No,
I absolutely, and I appreciate you saying that. It's really nice to know that it's actually hitting target audiences and people are getting some value out of it. All right, well, why don't we start very broad and then we'll get a little narrow. So listening sessions, what is a listening session? Why do you call it that? Let's start from there.
All right, so let me take one step back and say that I always start my mediations once everybody's situated, whether it's virtual or in person. Once everybody's situated, I like to start with a meet and greet where we cover just process and ground rules and no substance. And then I go into what I call a listening session. And a listening session is when I meet with each side by themselves, caucus style, and I just listen. Literally, that's the point of the listening session. I do a pre-call with each of the attorneys before the mediation. And I cover a lot of things in that pre-call. But because I've already read the information they sent and had a pre-call with the attorney, the purpose of the listening session is to hear from the client. It's my chance to listen to the client, whatever they want to tell me. They want to complain about traffic that morning. Okay. They want to tell me their life story. Okay. They want to tell me about their case. They want to, whatever the thing is they need to share, I'm there to listen. And so when I first started out as a mediator, I realized that a lot of times two things were happening in that first discussion in the caucus. One, the attorneys were doing a lot of the talking. And two, because the attorneys were doing a lot of the talking, the focus was entirely on, here's what we want you to tell the other side. Here's why the other side's going to lose. Here's what my offer is. And I realized that we were skipping a step, which was the step of connecting with the client and hearing from the client. And so you'd asked a minute ago, how did I come up with the name? I came up with the name, I did it myself. And it was because I realized I needed that chance to listen. I could also call it the connecting session, but that kind of makes people uncomfortable. So I went with listening session.
Well, I hope you haven't trademarked it, because I may adopt that as the term I use, but
I think everybody should use it.
yeah. And it's I think you hit it on the head in terms of the need. And I think one of the things I want to unpack a little bit is why that need exists, what the purpose of it and maybe the value of it is. And, maybe that'll help some of the attorneys out there frame it. The way that I try to think about it is sometimes a client needs catharsis, right? And that's a question I always ask in a pre-mediation phone call. I also agree having those calls is so critical, but does your client need catharsis? Have you asked your client that question? Have you gauged that for your client? And, not every lawyer knows the answer to that question, but that's something that I think more litigators should start to do, is ask that question in advance, get a feel for it from the client, because the lawyer may have never done that. The lawyer themselves may have never, sat and listened patiently and let them tell their story and whatever it might be. And then there's also, I think, something else that you alluded to, I want to hear a little bit more about your view on, which is establishing that trust and that credibility with the clients, because at some point in the day, we often are going to be asked to help evaluate the case or to help, express the strengths and weaknesses or the values and resolution. And if you haven't, as the mediator, established that trust, then you don't get very far. And I think that what you just described with the lawyers stepping in and taking control and telling the story and all that is a missed opportunity, for the mediator to connect with the clients who ultimately are going to have to make the decision. So what are your thoughts on kind of maybe those two elements of the value of the listening session?
I think that is the crux of why it's so important, is it, and I think it's also important to say, this is not done to undermine the attorneys. I think this is let's just, talk about the elephant in the room. I'm not doing it to take away anything from the attorney. I'm actually doing it to enhance the attorney's ability to serve their client. Because when I talk as a neutral person who has come in, who's not there with the role of advocating on their behalf, sometimes the clients will tell me things that they never told the attorney.
Yeah.
Right? It's not because the attorney didn't do a good job. It's just because the attorney is approaching the situation from a different place. And so it's my way to help the mediation, to help the process. But a lot of times it can also help the relationship between the attorney and client. Not that they have a bad interpersonal relationship, but help the understanding of the situation. And so I really use the listening session as a way to really dig deeper with the client, to understand, why are we here? And literally, I will say, this is your chance to tell me, why are we here? What's going on?
Yeah.
And sometimes I get things that have nothing to do with the case. Sometimes I get, a really gut-wrenching, heartbreaking story about what led us to this moment. And sometimes that gut-wrenching, heartbreaking story doesn't have anything to do with the merits of the case, but maybe it has to do with the ability to settle. Maybe it has to do with the ability to move forward in the process. Maybe it has to do with something I can't think of right now, right? Like, you never know until you give them the platform and the safe space to talk. And that's not, when I was I really, most of my work now is neutral, but back in the days when I was an advocate, that's not your role, right? As the advocate, you're listening to your client, but you're listening to your client to build your case.
Yeah.
As a neutral, I'm listening to the client to support them emotionally, to connect with them so that we can have a rapport but also to help understand the things that are below the surface, right?
Yeah.
Because so much of mediation and litigation, it's an iceberg. There's all the stuff that happens above, but really what I'm trying to figure out is what's the thing underneath that no one saw before.
Yeah. Yeah. What's the hurt that exists, or what's sometimes even just the need that has no real connection to the strengths or weaknesses of the case, and I like to focus a lot on the creative resolutions that can come from mediation. But, you talk to the client, you ask them what they want to do with the money from a resolution. And it's, well, I need to buy a new truck. I want to go take a road trip. And, like, that's what's motivating them to keep pushing forward. Well, maybe we can figure out some sort of a resolution that helps you get there, that, and so I think it's a critical value, exactly like you said, and establishing that rapport with them. And I think that when there probably are mediators out there who won't let the conversation deviate from the merits, and who it's, well, that's not what we're really here for today. I'd like you to tell me more about X. But no, if that person wants to tell you about the traffic that morning, or if that person wants to tell you about a different trauma in their life or whatever it might be, that's critical. A, it's critical information you might learn about that person, but B, that's a great way to connect with them,
Exactly.
And
I think it's incumbent on us as mediators to make sure we've prepped the attorneys before we get to that point. So when I do my pre-call with attorneys, I talk substance, obviously. We talk about the substance of the case. But I also let's talk about what my process is. And I'm happy to modify the process to fit the case. So let's talk about, are there special needs in this particular case? And, the way I approach it is I start, as I mentioned before, with sort of a meet and greet, process and ground rules. Then we do a listening session. And I tell the attorneys that I start that way. There's no opening statement at the very beginning. There's no sort of advocacy going on at the beginning, because a lot of times clients come to mediation really anxious. They're scared. They've never been there. This is a big deal to them. Something's happening in their life, whatever the reason. They get there and they're all wound up. And so I start with something innocuous, meet and greet, process and ground rules. It's just me going blah, 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 blah. This is what mediation is. This is how we're going to do it. Totally diffuse things. See, this has been a big, scary thing. Then we break into caucus and I do a listening session. So now this person who was really anxious and wound tight comes in. They first go through something. It's not scary. No one's in my face yelling at me. Then they go into a room and somebody wants to hear them. And connect and empathize with them. And so I explained to the lawyers, that's really why we're starting this way. This may not be the way you normally start your mediations, but I have found in my experience, this is the way to help us build a path to resolution. And that then once we get past that, then we'll go into the more traditional, what information do you want me to share with the other side? What's your opening offer? What's your counter offer? What are your thoughts? Those kinds of things. And by explaining it to the lawyers that way in the pre-call, oftentimes I get their buy-in. And they say, that's exactly what my client needs. And so when I first started out and I first started playing around with this concept of a listening session, and I found that if I cover it in my pre-call and get the attorneys to understand what we're trying to do and then do it, that they get it. They embrace the process. Yeah. And that's important because I want them to help me with the process, right?
Yeah. And that's the focus of this podcast, is trying to give some of those skills to the litigators. And I think that's a wonderful way to set this up. I've told attorneys in the past in pre-mediation phone calls that if your client needs that catharsis, if there's a particular reason, more than maybe some of your other cases, give them that heads up, prep them for it. Let them put together an opening statement if they want, not for the other side. We're not, I think a lot of people have moved away from that joint session model, although we'll talk about that toward the end of the podcast. But, what happens when a person feels the need to express it to the other side. But bottom line is, even if it's just to the mediator, it's, hey, especially if this is before a deposition, but even if it's after deposition where you're interrogated, right? maybe you've never really had a chance to tell your story from beginning to finish. Maybe you told it to a paralegal at the beginning when you were in intake, or maybe even an attorney, but have you had a chance to really just tell it to be heard and for the person on the other side to listen, to hear, not to respond, not to fish? Even the lawyers listening to that story at the beginning are listening to fish for more facts and to understand what the legal angle is. There isn't much of that listening to hear and feel heard. And so I've told the lawyers also, go prep your client for this. Tell your client, this is the process. We're going to start out with this time, your one opportunity, maybe your only opportunity if we get this case settled, to really tell your story. So think about what you find most important. Think about what you think it's important for the other side to know. And I think if you set it up that way, the more lawyers, the more litigators that represent clients in mediation that really take that step proactively, hopefully on their own, but certainly with our guidance, if you will, because that's a lot of what we do as mediators is, we're guidance counselors, if you will. I think it really is going to help the process. I think that it's so critical to have those listening sessions, but setting it up for that success is so important. So I love the way that you've, approached it with all the lawyers that you deal with.
I think you just hit a really important point, which is the lawyers need to understand we're having the listening session for a purpose that's different from the way they approached listening.
Yeah.
And that I think is critically important. And I love that you and I are completely on the same page about the need for these pre-calls.
Oh, yes.
The pre-call is not just to prepare me for the mediation, but it's to prepare the lawyer for the mediation too. And I always ask, and it sounds like you ask similar questions, is there anything else we should talk about? Are there ways that I can help you in this mediation? What is it your client needs from this mediation? And that's because I'm less focused on what I might be interested in if I were the judge or arbitrator, right?
Mm-hmm.
What's the actual right decision on the facts and the law? And more focused on how do I help both sides get to a place where we have a resolution?
I had one other anecdote, and I'm curious if you have any similar, but I had last week a mediation with someone with a medical condition, disability discrimination case. And he was really sensitive about the medical condition. He was, having a really tough time accepting it and accepting its limitations. And in my pre-mediation phone call, one of the questions to the lawyers is there anything that you think is a touchy subject that I shouldn't talk about with the client, something that you think might upset them? And the lawyer said, you can talk about the accommodation requests, you can talk about the medical notes and things like that, but I would try to stay away from even identifying this person as having this disability because it's a very touchy subject. And that was so valuable for this lawyer to have been able to recognize that this is something where I need to establish credibility with this client. I need to be able to, create that rapport and not upset them, not say something that's going to alienate them. And this is a potential landmine, right? It's like playing Minesweeper for, maybe I'm dating myself that I know how to play Minesweeper, but, tell us this, help us to understand, because we're coming in, we've read briefs, we've had our pre-mediation phone calls, and then we show up. The lawyers have sometimes had these cases for years and have had dozens of conversations with the clients. And so, each of those experiences kind of really teaches me the more you ask, the more you get to learn about what people might need in the process. So any fun anecdotes you can think of or examples you can think of where the listening session made all the difference, or prepping with a lawyer about a listening session did?
So I'll give you a couple of examples. So I had one case. This is not an example about a listening session. It is an example about the need to listen. I had a case many years ago where it was a fight over unpaid invoices. So pretty simplistic case. A said, I sent you 10 invoices, you didn't pay them. B said, I paid all the invoices I received. They were in litigation for years. One discovery battle after the next. The two business contacts hated each other. And so it was really driven by the interpersonal issues between the two of them. When I did my pre-call with the attorneys for each side, I asked each of them the most basic question. Has anybody sat down and reviewed the invoices to check in the system and see, were they received? Were they paid? Oh, I have to ask my client. Oh, and then the other side, has anybody checked to see, did you receive a payment? Like, if you just double checked to see if that invoice was paid? Oh, I'll have to check with my client. So I said to each of the attorneys, hey, bring all of your books and records. It was 2 small businesses, so it was easy to do. Bring your books and records, bring the people who understand that, not the 2 business people who hate each other, they can come, but bring the people who actually do the work.
Yeah.
And we sat down, we didn't do a traditional mediation. We sat in the room and those people, the bookkeeping people, went through, and after about 2 hours, they figured out some invoices hadn't made it in the system, some did. The ones that did got paid, the ones that didn't weren't paid, but yeah, they were valid and they got paid. Case settled.
Wow.
2 or 3 years of litigation.
Wow.
So that to me is an example of every step of the way, no one listened.
Mm-hmm.
Right? If anybody had been listening, somebody would have heard, hey, my invoice didn't get paid, or hey, I didn't get that invoice. Like, why'd they need me to figure it out? Right?
Well, yeah, why do they need you?
They couldn't get past that. And so they needed a neutral person to come in and go, wait a second. Now, let me give you an example of the use of a listening session.
Yeah.
I had a case many years ago when I did the pre-call. One of the attorneys said to me, my client is adamant. He wants an opening statement. He wants to start the mediation with an opening statement. He wants to tell the other side all of the horrible things they have done to him, how it has destroyed his life, and how they need to pay. And then he said, and I think if my client opens his mouth, we will never get a settlement. And I said, I've got a solution for you. We will say to your client that before he does that, we're going to do a test run. And he can tell me his story. And after he's told me his story, we can talk about it and what it is and how he wants to share it with the other side. So we get to the media and he's like, oh, that sounds great. I'll let my client know. So we get to the mediation. The client is just wound tight. He is ready to get this off his chest. We get to the listening session and out it comes. I mean, a deluge of emotions. And at the end, I empathized with him. I validated his feelings and he was right. I mean, it wasn't a fake thing. It was a very difficult situation. And so, I really connected with him because it was a hard situation. And then I said, all right, now I understand you want to share this with the other side. Let's talk about what that looks like. And he goes, like literally deflates in front of me. And he says, no, it's okay. I really appreciate you listening. I'd never had a chance to just really tell it before. Let's move on now. And we got the case settled.
I love that. I love that story. I think it highlights one of the most critical elements of it also, which is sometimes they need to have a tantrum and tire themselves out. I've got a 7-year-old girl who throws tantrums sometimes, and the child psychologists all say, let them throw the tantrum. You got to be supportive. You got to be there for them. But sometimes they just need to let that pent up energy and that pent up feeling out, And I think that was a really creative idea on how to deal with that emotion, how to deal with that pent up energy and feeling that this person hadn't had a chance to express. And
it also, when you use a listening session and you give the client that ability and you validate their feelings and sometimes maybe you give it back to them and you say, I want to make sure I understand what you shared with me. What you're telling me is, it also builds your credibility with them. So as you're moving through the process, when they say, I want you to tell the other side, I'm going to pound them into the sand and, all these really aggressive things, then you can say, I can understand your perspective on that. What if when I say to the other side, I frame it this way? And you reframe it in a way that is constructive, still gets their message across, but in a constructive way. Because you had that listening session, you built that credibility. A lot of times now, both counsel and client are on board with that. They say, yeah, that's a better way to say it to the other side. It might get us where we want to go.
Yeah.
And so I have found in my experience that the listening session helps me throughout the rest of the process.
I agree. And I think you touched on this a little bit, but it's a great pivot into a piece of this conversation, which is how to structure that session. What is the role, not just of the mediator, but also the lawyers in that session? And one of the things you referenced is mirroring, which is a concept from psychology where someone tells you their viewpoint on something, and before you respond, you mirror it back to them and you say, let me make sure I understand correctly. It sounds to me like what you're saying is you were very frustrated because, X, Y, and Z happened. Did I get that right? And did I miss anything? Is there anything else you wanted to say? Okay, thank you so much for sharing that. Now, let me give you my perspective. I hope that you can kind of reciprocate and just make sure that, and doing it in that fashion makes that person feel heard in a way that I think they otherwise wouldn't. And I mean, this is what all the psychologists say to do in relationships with your spouses and whomever else. But I think that's the first thing that I noticed in what you described as a tool and a method. And I want to hear a little bit more about what your views are and maybe any advice you would have for the lawyers, whether it's how to use that method in their own preparation with their clients to build that rapport with the clients themselves, whether it's how they can effectively assist the mediator or assist the whole process in that listening session, and maybe more critically, what not to do that might interfere with that. So I know that's a lot to unpack, but what are your thoughts on all of that?
So I think a critical part of the process is for each of us, counsel, client, mediator, to recognize our lane, if that makes sense.
Mm-hmm.
And so where I sometimes find that a lawyer may be attempting to derail the process is when I help reframe the issue in a constructive way to help us to settlement.
Mm-hmm.
And the lawyer says no, because it's usually the lawyer, not the client. The lawyer says, no, I want you to say it this way. I want you to tell them that they're going, and it's a very aggressive statement. And so that is one place where a lot of times it takes a minute
Mm-hmm.
for me to help the lawyer dial it back. And I usually do it by saying, can you share with me how you think that's going to help the process? How does that help us get to settlement? Because that's my job, right? My job is to try and help you find a path to resolution. And a lot of times that'll diffuse the situation. Then the lawyer will be like, I can see that might upset pique their anger, and we'll just play tit for tat instead of making progress.
Yeah. And another way to phrase that is, can you share with me how you think the other side is going to receive what you're saying? It's the same kind of the flip side of that same point. I think kind of can reframe that lawyer to understand, well, no, that's a fair point. If I were in the other room representing them and I heard that, how would I feel?
Absolutely. That is absolutely the right way to approach it. Is sometimes we have to help people get out of their own skin.
Yeah.
Step into the shoes of someone else so that we can serve the process.
I'll just tell you, there's an old joke that before you criticize someone, you should walk a mile in their shoes. That way, when you criticize them, you're a mile away and you have their shoes.
I've never heard that last one. That's great.
Good one.
I love it.
So yeah, so that's number one. I love that. That's a great tip in terms of the lawyers understanding when, not to get in the way of that process. What else?
Right. So, I know I keep circling back to the pre-call, but
Yeah.
I had a case many years ago or several years ago where in my pre-call, the attorney said to me, was totally candid, and candor is critically important. If lawyers listening to this take nothing else away, candor with your mediator is critically important. So this attorney said to me, Sylvia, this client is a brand new client, and I want them to perceive me as a bulldog of a litigator.
Mm-hmm.
But my client has unrealistic expectations about the case. So I am going to push back on you hard all day.
Yeah.
And I need you to help my client gain a new perspective and to push back on me. And then when you're out of the room, I'll say to the client, oh, actually, she has a point, maybe. And he said, but I need to do this from a client relationship standpoint. It's not my role to say, well, I don't know, that's the way to build a client relationship. Maybe it is. Maybe it isn't. I don't know. I don't have an opinion on that. But having that information dramatically helped the process.
So critical.
And we got the case settled. And in that particular case, there was a need for a listening session on each side. So his client was the defendant. The plaintiff had suffered major injuries, and it involved a minor who had suffered major injuries. But the defendant had a lot of emotional issues too around what had happened. And so the listening session was critically important there. And then I was prepared for the attorney to be a bulldog and for me to be able to push back and then say, how about if I step out in the room for a minute and let y'all talk? Step out, come back. Oh, okay. You like with the reasonable thing I said? And so I think that, listening sessions, I think, are critical from our perspective as mediators. Candor, as I said before, if lawyers take nothing else away, candor.
Be honest with your mediator.
Most important thing for lawyers to take away. Tell me the truth.
Tell me the truth. And I love that story because it highlights the core of this whole episode. And that is, the more that the litigators, the more that the lawyers representing the clients in the mediation can understand the value in sharing this information, in thinking about these issues, right? It's not intuitive for most people. It's not intuitive for lawyers, especially because they're advocates, they're adversarial in nature, not in nature, but the nature of the job, to start to think about things like psychology and understanding people and understanding what someone might need. And that lawyer was able to pinpoint that my client needs to feel like I've advocated for them in the strongest way possible. But at the same time, they also need to be able to hear from a neutral third party why some of that advocacy, why that isn't, necessarily going to win the case or whatever it is. And for that lawyer to have been able to understand that need and express that need is so critical. And getting to the point of candor I actually think it's a step before candor, because you need to actually be able to even understand what it is you need to be candid about before you're candid, but 100%. And then you need to be candid about it. You need to be able to tell the mediator. But I think that's a great example. I think that's one of the biggest takeaways I would love to see the lawyers take from this process is, don't just show up to the mediation and, oh, it's the mediator's job. It is. I mean, you pay us well to do a job, but the more you can give us in terms of information about your client and what they may need in this process, the better. And so ask these questions, start thinking about these issues weeks in advance of the mediation so that you can prep us and arm us with what we need to know.
And I think it's important to recognize that this particular lawyer had that insight about himself, his client relationship, and their needs, and was able to share that with me, which goes to the fact that the lawyers need to prepare for mediation too.
Yeah.
Not just me preparing for mediation, you as counsel need to be preparing for mediation and thinking about how can we help your client get to resolution. And I think that's important. I also want to say sometimes what I'll find is some clients need to tell their story more than once. That's okay. If it starts to become a problem where it's meaning we're not going to be able to finish that day, it's not as okay. But if they need to tell me their story 2 or 3 times, that's okay. But sometimes the lawyers are like, you did it once, that's enough. We don't need to spend time. It's like,
objection, asked and answered.
Right. Like, let's give them a chance. And so, I will often say to lawyers, maybe we'll go out in the hall or something, and I'll say, you got to understand that as a mediator, one of my jobs is to be bartender. Right. And I shared this with you when we were talking.
The ABCs.
Right. I talk about the ABCs of mediation, and the B is very important. It's bartender. Right. Sort of the classic story of somebody goes and sits at the bar and pours their life story out to the bartender. The bartender doesn't go, you got your 10 minutes, you're done.
Right.
No, the bartender keeps refilling the drink and let the person go on and on and on until they have experienced their catharsis. Same thing.
Yeah, having the patience to listen to the same story over and over is, I think, a critical skill of a good mediator. And this could be an entire episode on its own, and I probably will at some point do one, but I'm writing an academic article with a PhD in psychology on the use of attachment theory in mediation, which is the concept that different people, based on the way that they were raised, have different attachment styles. And you have anxious people on one side of the spectrum, and you'll have secure people in the middle, and then you'll have avoidant people on the other side. And something I've noticed as a mediator is sometimes you come in and that person does not want to look you in the eye. They don't want to tell you anything. You just try to ask them questions. They just, they're fidgeting on their phone. They're looking away. That person, in my view, is avoidant. And I bet if you did the attachment style test, they would actually, tick off all the avoidance. And then you have the person who comes in and they just need to tell the story over and over, and they need to know what's happening in the other room and what did the other person say about me, and what, and that person, in my view, is clearly on the anxious side. And being able to understand psychologically how to deal with this, because it's something that's been researched a lot in relationships, is how do you deal with the different attachment styles in conflict, right? There's a lot of research in divorce and things like that. How do you deal with different attachment styles? I think there could be a lot of application in mediation. And if mediators become trained in understanding that, it could be critical, but especially if the lawyers can start to recognize those cues about their clients and give us that heads up, like coming in, I sat with my client for a couple hours in preparation for this. I asked a lot of questions. They didn't really give me a whole lot of information. They kind of, were avoiding the questions and didn't want to talk about it. And maybe you have some ideas on how to deal with that in the mediation process. And now you as a mediator are empowered to say, well, what does the research show? How can I approach this specific individual to help, really get them the catharsis that they really need, but don't even realize they need, and B, make this a productive conversation where we get facts and information, and so I think what you just described it plays directly into that. Is sometimes they need to tell the story over and over and over, and you need to be able to listen, and sometimes they don't, and being in tune to what it is they need is a critical piece, I think.
I love that you are looking at attachment theory and how it plays into mediation. I do that a lot too. I read things that are sort of tangential to mediation, to learn new things that I can carry into mediation. So I think that is fantastic. And when kind of going back to the ABCs that we were talking about before, it ties into that. So for those who maybe haven't ever heard me talk about the ABCs,
tell us what it is.
It is analyst, bartender, and chameleon. And that is because as a mediator, I'm an analyst, meaning I analyze the information that has been provided, the facts, the law, but also a lot of subtext, interpersonal issues. I'm analyzing the data I'm taking in, whatever kind of data that may be. I'm a bartender, which is listening, and I do a lot of bartending in many mediations. And I'm a chameleon, and this is where the attachment theory comes in, because we as mediators may not be the same person in each room.
Yeah.
We may not even be the same person in a given room throughout the day. So, for example, I try to avoid at all costs being evaluative early in a mediation. I don't know enough. And I will literally say to people, they'll say, well, can't you just tell us what you think this case is going to, and I'll say, I don't know enough yet.
Yeah.
You need to go through the process more before I can do that. But later in the day, when I feel like I know more and I do have some thoughts and opinions about it, now I put my evaluator hat on, and so I'm a chameleon, and I might shift focus, and I might start out all warm and fuzzy and touchy-feely, and by the end be, look, this is really, let's be pragmatic about this.
Yeah.
This is the way, this is really good for you. You need to be thinking about this and this kind of, and I think it's such a big part of being a mediator.
Yeah.
We really have to be nimble and flexible throughout the process.
Now, I do have a question kind of, relative to that, which is my philosophy in the listening session stage is to spend most of it focused on the client but to find a way from my own personal life to connect with them in this story they're telling. And, it's a very delicate balance, because the biggest flag about listening and about mirroring and about listening to hear is not to interject yourself. The conversation is not about you, it's about them. So making sure it's done in a way that doesn't make it feel like you're turning the conversation on you is so critical. But at the same time, I had a case a couple of weeks ago where someone, it was a personal injury case. The guy had a back injury, and I've struggled with back issues in large part due to weight, and I've lost a lot of weight now. It's resolving, but I said, yeah, I've had some issues at my L5S1, and I've had pain, and I have nothing. I can't ever fathom what you've been through. This accident was horrific. I've had surgeries, I haven't, but I can understand, I can empathize, and, understanding that this is going to affect your life. I know every morning I wake up, I feel it. And I didn't do that off the bat. It was after he had told me everything. And throughout the day, it kept coming up, yeah. And Abe, you know what I'm talking about. This is going to be my life every morning. And then at the end, it's, Abe, I really felt like you understood the pain I was going through and what I was dealing with, and really worked hard and fought hard to get me what I needed to make myself whole for the rest of my life, and it wasn't a very lengthy conversation. It was just a couple of minutes of finding a way to personally connect. And I think a really good mediator is someone who can connect with anyone from any walk of life in some way. You can find some life experience to draw on. And so I'm really curious what your perspective is, because I do know that there are many mediators out there who are vehemently opposed to this, who say never bring your own personal. And it's not because I think you're going to alienate, or it's like there's this sacrosanct division between mediator and client. Never talk about yourself, never bring your personal life into it. And I think it's such a missed opportunity to connect on a real human level. And imagine if you're that plaintiff who's sitting there and mediator one is saying, yes, I hear you. It sounds like this was a horrific accident and your back has been hurting. And it's, well, did you really hear me? But mediator two is, wow, I can only imagine, I've had back issues, and it's like nothing compared to what you've been through, but I can imagine what it would have been like. And does that person feel much more heard once they've heard that, that you actually heard what I was saying. You heard me describe this. You heard me describe the pain I'm feeling enough that it triggered your empathy and your expression to me of something you've experienced in that realm. So I think it's so critical, but not every mediator does. What are your thoughts?
So I too try to connect in some way or on a personal level. I think that it's important to keep in mind, whatever that connection is, it must be authentic.
Correct.
So let's use the back pain example. I've never really had back pain. I have to find a way to authentically connect with them. And so it may be, using that example, maybe, oh, I've never had back pain, but I have experienced chronic pain. And wow, it makes you so tired all the time. It makes you so irritable all the time. I'm so sorry. It's so hard to live with that. You have to find an authentic way to connect with them. But I agree that it is incredibly valuable if you can do that.
I think that's exactly right. It needs to be authentic. But if you search for it, you shall find. Oh, I've never lived with chronic pain, but I watched my grandmother as she deteriorated because after she broke her hip, blah, blah, blah. Whatever it is, find that authentic experience that you can draw a parallel and then connect in that way. I think it's so important.
I agree. But I also think the point you made before about it, that you don't want that to dominate the conversation. That's sort of like a parenthetical added on that says there's lots of listening and empathizing, validating and supporting. And by the way, here's how I really understood you. Yeah,
I agree. And it's a hard line to toe, but it's one that I think the value of having that done right is so valuable that I think it's worth the risk, if you will. So I don't want to keep you too much longer because you've given me a lot of time. I want to just kind of close out on one topic that comes at the end of this. What do you do when a party in a mediation actually does really insist, I need to be able to say this to their face? I need to be able to express what I've been through. I need to see the look on their faces. I need to hear that apology. What do you like to do? How do you approach it when someone says, and obviously, it might be they just need the catharsis, they tell it to you and they're done. But when they actually say, no, I really need to say this to their faces, what do you usually do?
All right. So there's two things embedded in what you just said. I always say to people who tell me I have to have an apology. Apologies are about timing.
Mm-hmm.
So whether one side says I must have one or the other side says I want to give one, it's about timing. If you apologize in an opening session, it is too soon. Why is it too soon? The receiver of that apology is not ready to accept it yet.
Mm-hmm.
They must work through all their stuff before they're open to receiving an apology. There is nothing you can say in that opening session that will resonate with them. So that's what I'll, on the apology, the timing is critical.
Yeah.
And the framing or wording of the apology is critical, which now segues to the first part of the question, which is what do I do when somebody's like, I must say this to them? I do a listening session and we do practice. I hear them out and I try to help them reframe what they want to say from a perspective of, let's try to share it in a way that is conducive, that will help you get to a resolution. I can understand wanting to look them in the eye to tell them how this hurt them or whatever the reason is. But let's do it in a way that they can hear it. Have you ever been in a situation where somebody comes at you and goes off on all the ways you've hurt them? Can you hear it? Can you receive that? How does it make you feel? And then when they start thinking about, this is literally, you said this, I don't know, an hour ago. How do you think the other side would receive that information? And I try to talk them through that. Does it work every time? No, but it does work most of the time. Because most of the time people are able to take a step back and put themselves in the shoe of, yeah, I do remember that time somebody came at me hard. And no, I was in fight or flight. I wasn't
ready to hear. Yeah.
And so I think those are different ways. Those are ways to handle those types of situations.
Yeah, I love it. I think that's so critical. And I think setting up the process, if it is going to happen, because, you know, I won't bring the parties together if they're not both okay with it. But there are times where, you know, many times it's only one-sided. A plaintiff feels the need to express it. The defendant says, you know what, we're professionals, we're adults, we can listen without reacting. We're okay with that. We don't need to respond, but we're okay with them coming in. And then it's okay, but there's no eye rolling. Right. There's no, that's crazy. You know, there's no theatrics. There's eye contact. There's nodding, there's actually listening. Like it needs to be, if we're going to do this, it needs to be done in a way that's respectful, that makes the person feel like you're actually listening to what they're saying. And if that works well, sometimes it changes the entire process, sometimes from that moment forward. And you're right, it's usually later in the day, but that's what the shoulders roll back and they're able to really focus on the getting over the final resolution line, if you will. But I think that's critical. So I appreciate that. The last question is, other than everything we've talked about, and we've covered a lot, and I really appreciate it. I hope the listeners and viewers recognize the value in what we've got from Sylvia. But is there anything that you see a lawyer or a litigator right now not doing as well as they could that you feel might interfere with the value and the goals of a listening session, aside from prepping the clients for what it might be and, you know, interrupting and saying things like, you've already told that, or is there anything else you can think of that's so critical that the lawyers need to understand about this process?
Let me help you. Right?
Yeah.
Help me help you.
Help me help you.
Help me help you. Let me help you.
Yeah.
Because sometimes what happens is when the client's telling their story, it starts to deviate from what the lawyer had told me.
Mm-hmm.
And the lawyer gets anxious and they want to shut it down. But you gotta let me help you, because if that client doesn't get to tell the story, we're not going to make progress.
Yeah.
So help me and let me help you.
Yeah, you know, it's a can of worms in some ways, because I have so much to say on that topic, but all that I'll say is I think that's so right. And the mediation confidentiality is there for a reason. In some states, it's way more protective than others, like California. But be candid with the mediator right? I won't go share with the other side. If your client blurts out in that session to me that they really think the reason that they were fired was not discriminatory, it was just because they've always been out to get me, I'm not telling the other side that piece of information, but we in this room all now know that changed this case a little bit. And I think with the listening sessions, another thing I find is a lot of times we're developing the case. Like sometimes at the end of it, I'm like, oh man, now the lawyer realizes they actually have a stronger case than they thought when they were coming in. It's going to be an impediment to settlement. But sometimes you'll ask, oh, so did anyone else in the workplace also not have the ability to take meal breaks and rest breaks? No, actually, everyone else was able to take it. It was just me. And then the lawyer's cringing like, that kills our class action allegation. What? Yeah, but that's also authentic and truthful. And now the client's a little more believable about the fact that they didn't. And let me use that information in a productive way and let me help you evaluate it, even if we never share it with the other side. So I love that. Let me help you. I love the way that you phrase that. Let us help you.
Yeah.
All right. Well, I appreciate it. I'm going to ask the last question I always like to ask, which is just what is it about this that you love that keeps you going every day? Why do you enjoy mediating cases?
I love helping people. It is so incredibly gratifying to help people find a resolution.
Mm-hmm. Is it the creativity of helping people come up with a solution to a problem? Is it the just enjoyment of seeing people reach a point of resolution and being able to, get back to a space of peace? What about it is the most valuable in your view?
I love the creativity. I love the fact that it is both EQ and IQ challenging. I need both of those challenges. But I have had a handful of mediations where at the end, the plaintiff cries and thanks me.
Yeah.
For letting them put this behind them. And that doesn't happen every time. But when that does, it both breaks your heart and warms your heart, if you know what I mean.
Yeah.
We have the opportunity to truly help people in a meaningful way every day through mediation.
Yeah. Yeah. And to bring peace. And peace doesn't mean justice. Peace means peace. It means that person can start focusing on a new chapter. That company can focus on the core values that it wants to be dealing with rather than the lawsuit. It means that they can just go back to peace.
Right. Closure.
Yeah.
It means closure.
Closure. Yeah. Well, I love it. And I appreciate it. And it's very clear to me that this is something you're really passionate about. And so I appreciate you taking the time to join me today. And I'm sure the listeners and viewers will gain a lot from it. And yeah, hopefully we'll have you back another time to talk about another topic.
Well, thanks for having me. I loved our chat and I loved how we were in complete agreement throughout. Everything. We really connected. This was a good example of listening and connecting. Right?
Exactly.
We really connected and we're in agreement, which I think is fantastic.
I appreciate it. I think we're both in alignment in terms of philosophies. And so it's enjoyable to talk to people that are like-minded in that way. So thank you for being here, really, truly.
Well, thanks for having me.
My pleasure. Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you and keep calm and mediate on. Thank you.